SJC-13446, Commonwealth v. Raymond, Gaines.
Okay. Attorney Lewis.
Good morning. May it please the court. My name is David Lewis, and I represent the Commonwealth. The motion judge made a number of errors of law in this matter. The Commonwealth believes that her order should be vacated and the convictions in this matter should be affirmed. I'd like to start talking about a particular error of law in holding that an affidavit created some 14 years after the conviction was qualified as a Brady obligation to be disclosed, and that was an error entitling the defendant to a new trial. Defendant's rights at trial, there's maybe no starker difference than between the rights that a defendant is entitled to when he's presumed innocent at a time of trial, and then the rights that attach post-conviction.
You concede it's a matter of a rule of professional conduct.
Yeah, 3.8 I, J, and K.
That's controlling.
I believe that is controlling. If you look at the case, which I believe is consistent with post-conviction conduct that once the conviction enters and the Commonwealth has proved beyond reasonable doubt someone is guilty, I think you look at the case law, court rules, and the rules of professional conduct together.
We haven't said anything one way or the other on Brady.
Pardon me?
We haven't said anything one way or the other on Brady post-trial.
That's correct. Yeah, a material that did not exist at the time of trial. That's correct. No, I did not find anything in that regard. And
so that's the beginning of it. So, but you still have an obligation, right? And it's, you have the main witness recanting. Don't you have to pass that on, even if it comes up in a co-defendant's case?
I don't believe I disagree that he's the main witness. I don't believe this is sort of a Jenga tower that removing him changes anything.
He's a pretty important witness. He's the one who identifies his client for the first time. His son, it's his son who's the original person they identified, right?
There was his wife's, I think it was his wife's son, and then ended up being son-in-law, who testified, Alfred Hamilton testified at trial.
Pretty important witness, yeah.
So between the Anderson transcripts are part of this record. And between the two cases, there are 19 Commonwealth witnesses. There's 6 that don't overlap. They testified at one and not the other. And you have civilian witnesses, you have police, you have from different phases of the whole.
Before we get to harmlessness, though, but it just seems like this is a material witness recanting post-conviction, whether it's a code of professional responsibility obligation or a Brady. This is the kind of thing we want turned over, don't we? Because otherwise, there are real problems out there.
Well, that's the thing. I think if you look at page 131 of the Commonwealth's appendix, you have the Commonwealth's position at the time of this document, of this first affidavit, actually the 2 affidavits. And what it seems to me that does create, something new comes in. And what the Commonwealth absolutely has under duty or competence is to inquire into that. Is it new material or credible? That's what the ethical rules require. And in this case, unquestionably, that's exactly what happened. They didn't just dismiss it because it looked like it was written by a jailhouse lawyer or whatever. It wasn't that. If you read the Commonwealth's opposition that was filed in the Funderburg new trial motion that was litigated in 1992 before Judge Tuttle, it's very clear they have references to the record in that case and the Anderson trial. And
just to push that a second,
sure.
And Justice Gaziano is better at this than I am because he wrote it, but didn't we say we don't want credibility determinations pre-trial being made by the prosecutors? Now we're going to say that the prosecutors can make credibility determinations post-trial on this kind of information?
Well, in this particular case, it was validated by a Superior Court judge.
Well, baked into the rule of professional conduct is credible.
New material credible.
As opposed to Brady.
Adopted in 2016, absolutely.
But if we were moved to a Brady, then that would take it out of that credibility assessment would leave if we were to make it if we were to have a post-trial Brady obligation.
Right, but you'd be changing the basis of the case law, court rules, and that the rules of professional conduct. Because don't forget, on the post-conviction rules, now that they're convicted, Rule 30C4 puts the burden on a defendant to come forward with affidavits or other matter from 330C3 and create a prima facie evidence that they're entitled to more further discovery, presuming, of course, Commonwealth has followed Brady and turned everything over that they're supposed to, right?
What would be wrong with a legal regime that would require prosecutors to disclose this kind of recantation affidavit?
So
What would be the problem, either practically or legally, with that kind of regime?
So I think you've actually got, just to step back a little bit, and we'll get to your answer. I think you've got two issues here, and they get a little conflated in this case, I believe. You have one issue where you have co-defendants who were consolidated at trial, who are usually consolidated on appeal in front of your court or the appeals court. And then post that direct appeal, just procedurally, everyone sort of goes into their silo, right? So you've got a situation of, for lack of a better way to put it, sort of transparency or notice between previously consolidated co-defendants post direct appeal. They litigate their cases, and there's no obligation to tell anybody what they're doing, whether it may pertain to them, but they have no obligation to tell them. And to get to the second issue is what we're sort of talking about now, is material that comes to the Commonwealth, right, that the Commonwealth is making an assessment, at least under the current professional conduct rules, making this assessment. And you're saying, what happens if you just require it all to go? And what I'm saying is the current, for good reason, the current case law, court rule, professional conduct, put the burden on the defendant as the most interested party to come forward with affidavits in 30C3 to prove their point in 30C4.
I'm sorry, with affidavits of what?
To support the reasons why they require a new trial or need a new trial under 30C3, right? 30C4. And this is why that's important, particularly important, is, well, two reasons. One, you're putting the burden on the most interested party, right? You want them to be, that party to be the party moving. It's also important because they're also going to be the most knowledgeable party at that point. The Commonwealth's not investigating anymore. They've already turned everything over.
Counsel, I do have to stop you because I still want to get to Justice Wendland's question. Mm-hmm. Okay, I give you all that when it's the defendant is looking for a new trial. What's the principled reason in this case, where you have co-defendants and in another case the Commonwealth gets an affidavit that arguably is recanted for all purposes, and whether it's not the other co-defendant is moving for a new trial or not, you get it. What's the principled reason to not require the Commonwealth post-disposition, post-trial, to say, I'm going to turn it over? What's the principal reason for that?
The principal reason for that is it's entirely, no, in this particular case, it's entirely not credible. And in the end, and the second affidavit comes in from the same person.
I mean,
that
the
inculpates
Commonwealth's
defendant.
position is always going to be that it's not credible because the witness is recanting. I'm confused by that. I mean, could that really be the metric? Like you have, let's just assume for the purposes of argument that this was a material witness who said, this defendant did it. He was the one that ran into my apartment, and I heard him interacting with the other co-defendants. The Commonwealth's position, which they marshaled at trial, is that that's true. And now we have an affidavit that's saying, I completely made that up.
And the Commonwealth did exactly what you would want them to do in this case. What did they do? They go to the evidence that was in the case, and they see his wife testified the same, Alfred Hamilton testified the same, Anderson gives a voluntary confession.
So my question, which I don't think you ever answered, is what would be wrong with the legal regime that would require the Commonwealth to disclose that to the co-defendant? I'm not saying that the recantation is true, not true. I don't know. But why do we have the Commonwealth making that call? What's the value of that?
Because at that point, the defendant is the most knowledgeable party. The Commonwealth is going to have...
The defendant doesn't know about the affidavit.
The Commonwealth is going to have no idea of any of the security issues involved with turning that over. You have no idea, right? You have no idea if you look at some of the rules that are I think New York State...
What security issues?
What if their affidavit, let's say something comes in, and if there's a security issue with one of the other witnesses, you don't know how it
No,
impacts.
I'm just trying to understand what you're saying.
Well, I
What
guess
are you
Say
arguing?
there's no lawyer anymore for the
Right.
co-defendant. So you would be given the affidavit to the co-defendant who's serving a prison sentence.
Right, or you have no idea, because the Commonwealth at that point, post-conviction, the Commonwealth attorney that's on this is not going to have the knowledge of the case file to know all that.
Well, this gets to my question, which is maybe just a different version of Justice Wentland's question. So, in my understanding, when we think about Brady violations, the focus is on the prosecution team. And how do you conceive of, and particularly in the circumstances of this case where it was so many years later, how do you conceive of what, if the court were to go in the Brady direction, what the prosecution team would be? And also, second part of the question, I'm not familiar enough with this record to know the personnel who are present at this key moment in the early 1990s versus the personnel at trial. And can you comment on if there's any continuity there or not, vis-a-vis the point that you were just making about the Commonwealth having the knowledge to connect all these pieces?
Second question first, completely different. It was,
That's enough said. But so can you go back to the first question about the meaning of the prosecution team? Do we just conceive of the whole DA's office as the prosecution team once it gets to be post-conviction?
it's going to be, typically, at least in Suffolk, it's going to be in the appeals unit. And especially 15 years later, no one's going to be involved in the case that knows the case to any depth of specificity as far as what does this mean to another co-defendant, or what does this mean in this case? They may not know.
Well, the affidavit itself specifically recants testimony inculpating a specific man who's in prison. So the Commonwealth is, in this case, is pretty easy, right?
Well, I think in this case, it's pretty easy in the sense that the Commonwealth, I think they were eminently reasonable to wait until the litigation for the new trial motion played out. I think that's absolutely reasonable, because then a second affidavit comes in inculpating Mr. Gaines. That same witness comes into the hearing testimony, again inculpates Mr. Gaines. He puts the gun that killed Mr. Sorvaro, the .22 caliber weapon. There's support in the record that was Mr. Gaines's weapon. So on page 459 of the Anderson transcripts. So I think they were eminently reasonable at that point to wait. Then Judge Tuttle sees the witness, right? Sees him. He testifies, finds him not credible,
Because
and
he's
then
drunk.
and makes his
Because
rule.
he's drunk.
Well, he finds him. He reviews the record. It's not like he's drunk. I'm not believing anything he says. He reviews the record.
Bass's testimony shifts, correct?
In that regard, yes. The first affidavit says, not Funderburg, Gaines, and Anderson, and then he comes in later with second affidavit. So, well, it was just not Funderburg. It was Gaines and Anderson, and then that's the way he testifies according to Judge Tuttle's order.
To the second version.
Correct.
Can you address, when we look at Brescia and Rosario and this confluence on the Rule 30, what you say essentially in your brief is that the judge cherry-picked and didn't take into account inculpatory facts. Can you expand on that?
Sure. So I understand, and I would never argue that a judge has to make a catalog of evidence in their case in an order like this, because, nothing would ever get done. You can't say that. But what you can say, and I believe what the cases do say, is that any order a judge issues has to be supported by that. It has to be consistent with the record in the case. And what I'm saying is that was an error, because if you look at the record in this case, things she never mentioned, that a second officer heard Mr. Gaines's admission on the flight back from Iowa. Mr. Anderson confessed. There was a voir dire at his hearing. It was found admissible by that judge. The tape and the transcripts were presented to the jury. This court reviewed at the direction of the Commonwealth. This court in 1997 reviewed those confessions, reviewed the record to see if there was any evidence of lack of voluntariness, and found there was none. So there's the confession out there that Anderson, Gaines, and Funderburg committed this robbery and murder, and she never discusses that. And I could go on, but I think there is a lack of attention to or explanation of contrary evidence that's directly contrary. And I'm not talking sort of nitpicking facts. I'm talking major facts the second affidavit, DeLoche, Anderson's voluntary confession. I mean, it's never dealt with. It's never addressed.
The other question I had was with respect to the expert witness testimony on identification. Gomes, it says the jury instructions are prospective. Here we have changes in law and science similar to DNA. Are you saying that because expert witness on identification is a soft science, or are you saying that we shouldn't look at it for future cases? Because as I see it, it's a change as we did in EPS. It's a change in the law, and the effect of it could be different. I mean, DNA evidence, as you know from doing the work you do, could be exculpatory or could be meaningless. It depends on if it's roadside litter, as we had in cases, or if it's the blood stain, right?
Right.
So why doesn't expert identification issues or testimony have the same post-conviction inquiry as does DNA or any other science?
I think it's different because the DNA or the shaken baby cases, it's just, depending on the result, it's just the case ends, right? If the DNA comes back and there's YSTR exclusion, it's over.
It depends.
Pretty much.
No,
At times,
we've had a lot of cases.
right?
It depends on what DNA we're talking about.
What I'm saying with this is the court has had, has issued a report. It has issued Gomes and its sort of progeny discussing this with the instruction that's now required to be given. What I'm saying is that to me, that identification science is sort of a prism, that it allows you to look and assess a risk factor. And what you do is you can see, because some cases you can say, all right, let's take a look, and there might be no risk, there might be a low or whatever. You can see from the facts of the case, sort of zooming in close. But then pulling back under a sort of confluence and factors analysis, right? Then you pull back and you can look at that. Once you know what you've got, then you look at the broad sweep. I mean, we've had a
What you're
case.
saying there.
So-
Like the shaken baby, in the shaken baby case, we said, okay, there's new science here that enables you to question this more. It's not conclusive. Isn't that similar to what we're dealing with here, which is the eyewitness stuff is shakier than we originally thought, and therefore there's new evidence here? To me, I understand this is a big deal because we've got thousands and thousands of cases based on eyewitness identification, but I'm just trying to understand why it's different than like the shaken baby decision we issued.
I guess what I could say is some of the reviews we've done where you look at some of these older cases, like you say, and they're just the way they did things in the 70s or 80s, right? And you sort of zoom in, you look at how it was done. It's like high risk, whatever, right? What actually happened? And then you look at the evidence in the case.
I understand the second part of the analysis when we've got to look at how meaningful this is, but isn't it new evidence in the same way? Go ahead, sorry.
Like, how we used to do things is we used to do blood typing.
Yeah, serology tests, sure.
Right, going back.
Yeah.
But now we do STR, PCR-based, very minute. So the answer isn't this is how we used to do things, because we have exonerations based upon STR testing when we had convictions on blood grouping. So I don't think that's the answer, is this is how we used to do things.
No. What I'm saying is, and I'll just, a specific example. So we've had a case where we looked at it, mid-70s identification procedures, right? Then we go and we look at the evidence in the case, and there was nothing. There was literally nothing else. No, right? And we knew, and that ended up being, we assented to that new trial motion.
Right, so
right?
That's what we're doing here.
Yeah, that's what I'm saying. And what I'm saying here, right, is you look at the procedures that were used, right? They were, and then you sort of zoom back out and you say, look, issue was argued to the jury, argues fully presented to the jury, right? Minus the expert, obviously, because that's now, right? Commonwealth in its closing, right up front, says, we made mistakes in this case in the beginning. And it's very upfront with the jury about it, right? And then you get a situation where the jury deliberated for, 2 hours or whatever. And then you get, in the case record, you have an Anderson voluntary confession, you have an admission from the defendant, you have other evidence of other witnesses who are not compromised in any way, no even accusation of it, and they all support those confessions. It's all consistent with those confessions. And you look at that and you say, yeah, is there a risk? Yes. Was there a substantial risk of a miscarriage of justice in this case based on the totality of evidence? No, there was not. Those 3 men were the men who committed this robbery and murder.
Okay, thank you.
There are no further questions?
Attorney Schnipper.
Good morning. Excuse me. Good morning. May it please the court. I'm Merritt Schnipper here on behalf of Raymond Gaines today. Mr. Gaines is able to be here with us today in the courtroom after serving 45 years in prison on the record that's now before this court. And I think it's fair to say that that record today looks remarkably different than it did the last time this court reviewed it in 1978. Before I get into the big picture issues, and this case presents many, I want to just push back against my brother's assertion that post-conviction criminal defendants are all in their own separate silo. The rules of procedure, and specifically Rule of Criminal Procedure 32A, requires all motion papers and responses thereto in all criminal proceedings to be served on co-defendants as well as the Commonwealth, or all parties. And if you look at the reporter's notes, it says that's specifically to ensure the full dissemination of relevant information. So it's difficult to think of a case that more exemplifies what happens when that rule fails, and that's a failure both by Mr. Funderburg's counsel, who also didn't serve Mr. Gaines, it's worth noting, but only one of those 2 parties, as to Mr. Funderburg and the Commonwealth, is responsible for depriving Mr. Gaines of his liberty and sending him to prison for his entire life. So with regard, moving to the big picture issues here, unless there are any questions about Rule 32.
That rule you cited is a pre-trial or post-trial rule?
It applies without restriction to pre or post-trial motions, and I would certainly note that it follows Rule 30 itself in the rules of procedure. But it does not refer to pre or post-trial motions, and you can contrast, say, Rule 13 in that.
Sorry, the rule is which?
Rule 32A. But I just want to, the idea that the motion judge was required to consider an inadmissible confession for purposes of assessing whether this jury trial resulted in an outcome that was inconsistent with justice, one thing that the Commonwealth has never addressed, and that's neither below nor in its briefing here, and of course thus the motion judge didn't have the opportunity to weigh in on, was the relevance of the Bruton rule to any potential consideration of that confession. Bruton.
Are you referring to Anderson?
I'm referring to Robert Anderson's confession, because one of the Commonwealth's primary contentions is that despite the just disarray that this record lies in light of our post-conviction case, the court can look past all the errors that the motion judge in her very comprehensive ruling found because Robert Anderson separately confessed to this crime. Of course,
What about Deloche?
Sure. Do you want to hear about the confession, or should I go right to Deloche?
Well, you have 12 minutes. Why don't you go
I
ahead
know.
with that?
Well, so the thing about Detective Deloche is that, of course, he does claim that he overheard Mr. Gaines speaking to Detective O'Malley on the plane, right? So the question then becomes, does that testimony from Detective Deloche require the motion judge to find that a jury would not have been impacted by all the other massive array of post-conviction evidence? And that's the recantation, that's the pretrial Brady violation in terms of the arrest of David Bass at his shooting gallery by Detective O'Malley, that's the new eyewitness identification science, and that's the significant evidence of misconduct by Detective O'Malley in this case, in multiple cases.
But counsel, one thing you leave out is Mr. Gaines' own words, putting himself there.
I'm addressing that, and that's kind of what I think Detective Deloche is about, because we've significantly impeached Detective O'Malley's testimony. Detective O'Malley is the person who claimed Mr. Gaines confessed to him. Detective Deloche, we were unable to uncover 50 years after the fact any evidence to specifically impeach him. So I would ask the court to look at that question in light of a number of factors. There's significant evidence of misconduct by Detective O'Malley, both in this case and out of it. There's evidence of Detective Cotter's misconduct in this case by covering up the idea of this call to Paul Sofaro in February 1975 by someone named Murphy, telling him that he had chosen the wrong persons the first time he did an identification procedure, and the police needed to come by and show him some new pictures, thus implying that not only did they, were the wrong guys picked the first time, but now we got the right guys in there in the array you're going to see this time. We also have, of course, the motion judge's adoption of, at my request, an adverse inference against the Commonwealth that it was withholding further probative evidence of police misconduct in discovery. And then finally, what we have, and I think I would really urge the court to think about when you think about Detective DeLoche specifically, and this point I think is very articulately raised in the amicus brief by the Harvard Criminal Justice Institute and Families for Justice's Healing, is that police misconduct exists as part of a culture. It is not acts of individual misbehavior by people who are deviating from a group requirement. What they're doing, of course, there are individual police officers.
We don't have fact-finding on that, though, right?
We do not.
We got two big issues in this.
Sure.
Case. Can you, I don't want to lose you before you address both of them, which is, are we going to have a post-trial Brady equivalent, and are we going to treat eyewitness identification science the same way we treated DNA in Shaken Baby? So
let me take the second first and the first second. We absolutely should treat them both. So we should absolutely treat eyewitness identification science as newly available evidence that defendants can bring in appropriate cases and show that their identifications were obtained in violation of all the principles we now know.
And I just want to understand how that's going to work, because I can't, I sort of agree with you that I can't distinguish the Shaken Baby analysis in, was it Marrero? I can't remember the name of the case, but
Epps.
So we've got thousands and thousands of cases out there in which we have the old way of eyewitness identification. Does that mean every one of those cases is a newly discovered evidence case if brought? I mean, I'm just trying to understand that.
So, for instance, any case that was tried and convicted before the advent of DNA could potentially be newly discovered evidence in that case.
DNA is sort of much more conclusive.
There's nothing like DNA, for sure.
This is different. This
But
is more like the Shaken Baby.
It's more like Epps, it's more like Rosario. There are advances in scientific inquiry that allow the fact finder to interpret trial evidence more effectively to determine the probative value that the fact finder wants to assign to that particular piece of evidence. So in any case that is susceptible to that analysis under an eyewitness identification regime, it is appropriate, at least for a defendant to have the opportunity to consult with an expert, look at the identification procedure, determine whether there's a basis, A, to claim that that identification procedure itself was unfair and produced unreliable results, and B, to look at that identification procedure in the context of the totality of the evidence at trial. So I'd say it's a lot like Epps, it's a lot like Rosario, but in one way it's so much more important, because you say there are thousands of cases. That's right, there are thousands of cases, and we have absolutely no idea, sitting here today, how many of those people are wrongfully convicted. But what we do know is that we now have a mechanism of analysis that this court recognized in Gomes is so powerful and represents the accumulation of so much scientific inquiry that is worth incorporating into Massachusetts law. We now have that tool available to us. And we should simply not be afraid that we're going to end up with too much justice if we let Rule 30 claimants analyze their identifications under this regime.
Just so I understand, your position is, yes, okay, so every case is a new evidence, almost every one of these is potentially a new evidence case.
I think in each case it has to be assessed whether the evidence is new.
For example, they didn't do the sequential photo, I can't remember the different examples.
Well, for instance, this court has repeatedly said we're actually not going to go there in terms of sequential versus at the same time, in terms of holding that itself renders an identification unfair. What's different here is that you have an eyewitness identification expert who really takes apart this identification in very, very close detail and talks about all the ways in which subconscious cueing were in effect, all the ways in which there were factors that were suggesting the particular people who should be identified to the witness. So if you have that level of analysis in any particular case, then it's certainly worth presenting to the Superior Court.
Did the witness address the fact that there were 60-some-odd photographs and then 63 photographs as opposed to these aren't the guys, right? So if you had 8 photographs and there's a call that says, you picked the wrong people, so take 3 out. Now you've.
Did she address how it would have gone?
It's the number of photographs that are.
Well, what she said was,
interesting to me as a,
I mean,
like,
she didn't.
that someone would memorize 60 photographs seems improbable to me.
Fair enough, and she certainly wasn't suggesting that the witness would have memorized them. She
Right,
would have,
as opposed to 8 photographs.
yeah, so I certainly think she didn't testify as to this, but I certainly
Okay,
think
that was a question I had,
Yeah.
whether she addressed that in
No, but she
testimony.
did certainly say that even in a mugshot book of this size, it's likely that the witness is going to subconsciously recognize the photos that have been gone through before and will also be drawn to the ones that that have not been seen before, and those are the people that the witness would not reasonably understand based on the phone call. The police believe are guilty, and that's why they're in the lineup. To go to the second part of the question about should there be a post-conviction Brady obligation, not only should there be, but there must be if we are going to ensure that the evidence in question is going to get into the hands of the party that has a motivation to explore it.
All right, walk me through this case, how that would work in that world.
Sure.
As far as, sorry, motion for new trial, recantation, you represent a co-defendant, you're off the case, right? You were trial counsel. What happens?
So what happens is the government says, okay, and again, there's Brady and then there's Brady. This is like Super Brady. This is, I lied at trial and I lied and cooked up this story with the investigating officers. So that's powerful stuff. So the first thing that happens is I go to the docket and I say, oh, okay, does the code, do you have a lawyer that's still of record? And if so, I just send that over to the co-defendant's counsel and I'm done with my obligation as a prosecutor. Again, 3.8I is a rule that requires notification to the court. In terms of security concerns, it actually includes a provision that the prosecutor can ask for a protective order from the court to not disclose to the defendant if in certain circumstances. But that's really not what the court should be thinking about in terms of triggering a duty. Triggering of the duty is from the right to produce all proofs language of Article 12 itself. It should be in Rule 3.8D, the one that just says the prosecution has the duty to disclose all evidence that tends to negate the guilt of the accused. There's no time limitation on that. And as this court has discussed, and as the motion judge specifically discussed, there is a time limitation in Rule 14, right? Rule 14 is a pretrial rule. Nobody's disputing that. But the fact that the defendant has a burden under Rule 30 to come forward with affidavits supporting his claim to a new trial has nothing to do with who has a disclosure obligation when it comes into possession of exculpatory evidence.
What do we do with the credibility part of the rule of professional conduct where the Bass affidavit shifts and then there's
Sure.
a finding that he's not credible?
So 2 things. So the first is with the credibility rule of requirement of Rule 3.8I, that's why it doesn't just require, like, because obviously pretrial prosecutors also think lots of stuff isn't credible, and they
I
still.
mean, this is a strange case, right? Because when they first get it, they don't know whether it's credible or not. Then it
Right,
might
but
trigger the
assuming that they
disclosure.
decide it's not credible, that relieves them of their duty to go to the court and say, Judge, we have a concern here. There may be a wrongfully convicted person in prison, right? That's when the government has an obligation. But of course, the defense has a very different perspective on what this evidence might mean for a person's freedom, a person's liberty, a person's wrongfulness of their conviction, right? So the defense has a different incentive to investigate it. Now, in terms of credibility of the David Bass affidavit itself, as I expressly conceded during my discussion with the motion judge that was extensive at the evidentiary hearing, David Bass is not a credible witness. What makes the affidavit credible, or at least worth hanging a post-conviction case on and building a post-conviction case around, is not simply what he says in its affidavit. It's the corroboration of that, what he says in that affidavit by an arrest report from April 1976 that shows that Detective O'Malley, the lead detective in this case, the person who convinced the court to accept Paul Sofaro's identification, the person who is the only real testimony to Mr. Gaines' supposed confession, arrests David Bass at the shooting gallery he's running 2 months before trial for possession of needles and syringes, a crime that multiple police officers acknowledged that they knew he was committing for years and they tolerated for whatever reason. And his affidavit, David Bass says, the first time I lied to help my son, Antonio Daniels, and my friend Alfred Hamilton get out of trouble. The second time I lied to keep myself out of jail and to keep my drug house open and my source of drugs available to me. So I argued, and the motion judge accepted in her decision, that indicated that what he was talking about is the fact that the government, Detective O'Malley, arrested him before trial, and lo and behold, after he testified compliantly in the Commonwealth's case, he receives no punishment, he gets a guilty filed, and he goes right back.
What do you do with the other motion judge's decision that finds him not credible, does that get the Commonwealth out of the obligation to do anything?
I don't think it does. I mean, it gets it out of our Rule 3.8I obligation, which hadn't even been enacted at the time of those proceedings. But it doesn't get them out of the obligation to disclose it because it's still facially exculpatory. And it's not just facially exculpatory. When you think about the way this court recently explicated the duty to investigate in Graham versus Hampton DA, so think about that for a second. You get an affidavit recanting trial testimony in 1992. The officer implicated in the recantation is Detective O'Malley. In 1991, just the year before, Detective O'Malley had findings made against him regarding misconduct in the Stewart case. If the duty to investigate is triggered, which it should have been by the Commonwealth's receipt of that affidavit, it's going to go to the police file in this case, and it's going to say, lo and behold, Detective O'Malley arrested this guy as recanting before trial. And that was never disclosed, or at least looking at our certificates of discovery, it doesn't appear it was ever disclosed. And the government is suddenly then going to find itself, wow, we actually do have a pretty credible challenge to a conviction here because we have an officer who's engaged in multiple acts of misconduct, we have a recanting witness who says he colluded with that officer, and we have a pretrial Brady violation based on a pretextual arrest by that officer.
Can you address the issue of cherry picking where the bargain I think we have in Rosario and Brescia is, okay, we're not going to have pigeonholes to keep justice from being done. So we're going to open it up and have a holistic view, but that also entails a view of all of the evidence in the case, good and bad, and judges do the work. And here we have instances for, we have the issue of the injury. Well, I didn't get, there's a note about injury, and it was a Brady violation, but it was the defendant who was injured. And the defense attorney had hospital records, and the judge doesn't address that. There's a lot of inculpatory facts.
The motion judge didn't
The motion judge doesn't address, which worry me. So give me your take on that.
Sure. Well, specifically with regard to the medical records issue, I mean, when this came up at trial and the government argued, hey, if he was injured, where are the medical records? The trial judge interrupted the closing to say to the prosecutor, counsel, the defendant doesn't have any obligation to produce evidence, and by the way, you could have gotten those records and you could have brought them in if they help your case. As I pointed out in my motion papers are gigantic and I couldn't summarize them all in my brief, but if the government had disclosed this affidavit when it received it, because the medical records in question were destroyed by virtue of an automatic destruction policy in 2004. The first thing I did when I got the affidavit is reached out to the Boston Medical Center to try to get them, and that's what their records keeper told me. I put that in my affidavit in my motion papers. But so the point here is the motion judge didn't address it because she found, as I argued, and I think correctly, it's a red herring. This evidence was available to both sides. It wasn't used by both sides. The only conclusion there is we don't really know what those medical records
But
contain.
you call it a Brady violation.
Well, the Brady violation is that there's a police note that says, Paps was shot in the leg, walking with the crutches in a cane.
Anyway, but I guess continue on with my concerns about cherry picking.
Well, I don't think cherry picking is going on here. I think there's an extremely comprehensive review of a trial record that has systematically been dismantled by a massive flow of post-conviction evidence. And I think when we talk about a confluence of factors, right, a confluence means multiple streams of a river coming together to form one single more powerful stream. And what we have here is a confluence of the multiple factors known to contribute to wrongful convictions. We have a bad identification, we have withheld exculpatory evidence, we have police misconduct. I mean, that's a confluence, and it's a confluence in favor of the extremely thoughtful decision that this motion judge reached, it's important to note, in significant reliance on trial testimony that she heard and credited entirely. So, I mean, she has not abused her discretion. I don't think there's any question that she hasn't abused her discretion. I think there's discrete and very significant legal questions that are subsidiary to that decision that this court is presented with.
What was the rule that you cited before that requires disclosure to co-defendants?
32A of the Rule of
32A.
Criminal Procedure.
Yeah.
Yeah, and then if you look in the reporter's notes is where they talk about they changed the rule from it used to be just on adverse parties, then they made it to all parties because they wanted to make sure that in co-defendant cases, co-defendants might not be looked at as adverse, and they still needed to receive the information so that everyone gets all the information. And the reason everybody gets all the information is so a person doesn't have to spend an extra 25 or 30 years in prison before the just completely rotten foundation of the conviction that sent them there can be exposed.
Forgive my ignorance. Did that rule exist at the time of the
And
post-trial motions?
forgive my ignorance for not being sure.
Okay. I guess we'll both look it up.
Yes, I guess we will. Well, I see my time is up. I don't know if there's any further questions,
I think we're all set.
but if not, I'll rest on my brief and ask that you affirm the order. Thank you.